Mr. Todd, and his client is going to be a Miss Lovig, L-O-V-I-G. So after I read the script, we will deal with Miss Lovig first, Mr. Todd, and his client is going to be a Miss Lovig, L-O-V. So if everyone is ready, I'll just begin.
Yes, Your Honor. Good morning.
Everybody slide down. And you can just come up and just stand right there at the end.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I am a judge in this court. I am not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. Not afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based upon a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity in an amount equal to 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you will remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. You are currently on active probation. This court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise their right hand. Will you swear or affirm that any statements made during this proceeding will be the truth, the whole truth, so help you God? Okay, we can begin with Ms. Lovett first. Ms. Lovett, you're being represented by Mr. Todd. And normally in these proceedings, I speak directly to the person, but because you have a lawyer, I'm going to be directing my inquiries to Mr. Todd. You should understand that any statement that you make is not going to be something that is going to be private. So you're not going to be able to have a private conversation with Mr. Lovick. Mr. Todd during this proceeding, Ms. Lovick. So please don't say anything that you wouldn't want the whole world to know.
Yes, sir.
Okay, Mr. Todd, it's nice to see you.
Good morning, Your Honor, and congratulations on your new position there. We look forward to working with you in the future.
Thank you. I'm going to receive the affidavit that you sent over, and I have reviewed the affidavit. I will tell you what I am most interested in, and then you can say whatever you want to say. In this particular instance, I did see that Ms. Lovick has a prior arrest for aggravated assault, but it appeared that that was no bill in 2016, I believe. So I'm not considering that as it relates to her eligibility for bond. I am concerned with the allegation in the warrant that I received and I read. And I did see that Mr. I think Tootin signed an affidavit saying that he did not make a statement related to Ms. Lovick. The warrant officer swears that Mr. Tootin did make a statement. So can you address that for me first?
Your Honor, if it please the court, Mr. Tootin at the scene, Judge, he was the only one. He made a written statement to the police and basically that what had happened in this particular case, these parties went to that location to do a job. They do a argument, nothing, no physical contact, nothing like that. Mrs. Lovick called her sister to come and pick her up from that location, which came to that location. And as she got in the car, that is, Miss Lovick got out of the car to get in, which she was in the process of doing. Mr. Tootin ran after her, or not after, but after her, pleading with her not to leave. She got in the car. Mr. Tootin, of his own volition, slipped and fell to the ground. Nothing to do with my client. She got in her car. Mr. Tootin fell to the ground, and she, unbeknownst to her, ran over his arm. She left the scene, no problem. She didn't even know she ran over it. Mr. Tootin, because he was left there by himself, had called. And so obviously at some point in time, the police came. Subsequently, he had a scrape on his scraper mark on his arm. I don't even know. But in any, she was leaving the situation when he tripped and fell, and he wrote out a statement to the police. That police that he felt wasn't requesting that anything be or thing actually be done under that. But the police, they have a statement that he made there at the time, Judge,
Mr. Todd, Mr.
Yeah.
Todd, would you stop for a second? I'm
Sure.
gonna ask over on the female side, if you
Okay.
would lower the volume on the computer, because I think it's causing some feedback, because your audio is coming in and out, and I see on my end, it keeps switching over to the lady side as if they're speaking. I think it's just your voice reverberating back.
Yes, sir. I'll put it on mute while he talks.
Okay. Okay, go ahead, Mr. Todd.
Yes, Your Honor. And so as a result of that, when the police were called, Judge, and he made a written statement to the police, I've actually seen the written statement that says exactly what I just relayed to the court, that he slipped and fell on the ground, and that's what happened. She left in the vehicle and didn't even know she had actually run over his arm in the process. But that's what transpired. That's what the statement he gave to the police at the scene, and he gave a written statement. And I've seen that written statement that he gave to the police. Obviously, Judge, I think in the affidavit I've provided to the court by Mr. Tootin, he reiterates that was the written statement that he gave to the police at the time. He was attempting to try to talk Mrs. Lovick into not leaving, and he had slipped and fell, and that's what happened. She left. She didn't even know that transpired, Judge. And I believe in his affidavit, he clearly spells that out in this case. And so the police officer took it upon himself to charge whatever he charged in this case. So I'm asking the court to reduce, as opposed to at this point in time. I think down the road, there's not going to be sufficient evidence there to do anything with it, but for the purposes of the first appearance hearing, Judge, at least to reduce the bond, reduce the charges so this court can set a bond in this case. And of course, it'll all be resolved, down the road in this case. But obviously, so that the court will have the ability to at least set a bond. Obviously, the jails are full. We know about the COVID problem. I don't have to go into all that stuff, Judge, but I'm asking the court to reduce it down to simple battery or something to that degree, so this court can set a reasonable bond and this matter can be resolved in the future, Judge, at the appropriate time. And I think the affidavit spells all that out quite in detail, Judge, as to what, not only what transpired, but what Mr. Tootin said.
So I can set a bond on the aggravated assault charge because she's not on bail, and she does not have a previous conviction. I had originally, this was going to be a no bond situation. I see that she has one prior conviction from 2001, and she's had other arrests, but it looks like that's the only conviction on her record. Now,
Yeah, sure.
as it relates to the affidavit that Mr. Tootin signed, of course, that's going to be a material issue of fact that I can't make a determination as to the truth of what is in the warrant or the truth of what is in the affidavit. What I'm willing to do is set a $15,000 bond on the aggravated assault charge because she,
Okay.
like I said, she is eligible.
Yes.
Is there anything else, Mr. Todd?
No, Your Honor, that was the extent of it. Thank you, Your Honor.
Okay, she's going to have a preliminary hearing date that's going to be set for April 12th at 8:30 in the morning. But if she bonds out, that date is going to most likely get, the charges are going to get bound over to Superior Court. So with that, I'll let you go back, Ms. Lovick, unless there's something else, Mr. Todd.
No, Your Honor, that completes the case. We appreciate your consideration. Good seeing you again, Judge. Thank you.
Yes, sir. You have a good day.
You too.
Ms. Lovick is free to go back.
Thank you, sir.
You're welcome.
Thank you, Judge. May be excused.
Yes, sir. Have a good day.
Thank you. You too.
Hey, Judge, next would have been Miss Baxter, Samantha, but she just had a medical issue, so she got transported to medical.
Okay. Is Miss Andino, is she OTB?
Yes, sir. Yes, sir.
Okay, thank you.
Okay, so next I have Calvin.
Good morning, Ms. Calvin.
Good morning.
You've been charged with 1 count of improper lane change and 1 count of driving while under the influence of alcohol. I'm gonna set a total bond of $5,500. You believe you can post that bond, ma'am?
Yes.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
See if I qualify.
You do qualify, Ms. Calvin. I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you have any questions of me?
I don't.
Okay, you're free to go back, ma'am.
Thank you, sir.
Next is gonna be Green, Erica.
Ms. Green, you've been charged with 1 count of criminal trespass. I've placed a $2,500 bond on this offense, but I've also placed a stay away provision to stay away from Philip Cribbs. Do you believe you can post this bond, ma'am?
Yes.
Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Ms. Green. I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date that's gonna be set for April 13th. That date is gonna get waived upon your bonding out. Do you have any questions of me, ma'am?
No, I do not.
Okay, you're free to go back.
Thank you.
Next is Miss Little.
Ms. Little, you've been charged with 1 count of battery. I've set the bond at $5,000 for that offense, but I've also set a stay away provision on the bond to stay away from Imani Perry. Do you believe you can post this bond, ma'am?
Yes, sir.
Do you understand the stay away provision?
Yes, sir.
Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
You're gonna hire your own lawyer or
Yes.
represent yourself?
I got a family lawyer, sir.
Okay. We're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you have any questions of me, ma'am?
No, sir. But why am I going 5,000?
That's the lowest amount that we set on battery offenses,
Okay. Okay.
okay?
Okay.
Anything else?
No, sir. That's it.
Okay, you're free to go back.
I go back to the.
Okay, the next two is a mother-daughter duo.
Right.
I'll try to keep them separated best way I could.
Okay,
So it's gonna be Melon.
Alderman Rosado,
Yes, sir.
okay.
Hello.
Ms. Milam, you've been charged with 1 count of aggravated assault. I've set a bond at $15,000 for that. I've also set a stay away provision on your bond to stay away from Amaya Rosado. Do you believe you can post this bond, ma'am?
Yes.
Okay. Do you understand the stay away provision?
I'm sorry.
Do you understand the stay away provision?
Yes.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
I'm gonna hire my own counsel.
Okay. You're gonna have a preliminary hearing date that's gonna be set for April 12th at 8:30 in the morning. but that date is gonna get waived upon your bonding out. The charges will be sent to the Superior Court. Do you have any questions of me, ma'am?
No.
Okay, you're free to go back.
Next is gonna be Ms. Rosado.
Okay. Ms. Rosado, you've been charged with 1 count of battery. I've set the bond at $5,000 for that. And I've also set a stay away provision on your bond, a stay away from Samantha Milam. Do you believe you can post this bond, ma'am?
Yes,
Okay. Do you understand the stay away provision?
yes, sir.
Are you going to hire your own lawyer, represent yourself? You want me to see if you qualify for the appointment of a lawyer?
I have a family lawyer.
Okay. You have, well, you're gonna have a separate date of April 13th as your preliminary hearing date, but that date also will get waived upon your bonding out. So do you have any questions of me, ma'am?
No, sir.
Okay, you're free to go back.
Okay, Your Honor, now to be the female.
Okay. Are you, Ms. Baxter, we're just gonna do her?
She probably will not return today, so I guess you can put her on the calendar tomorrow.
Okay, I'll make a notation of that.
Yes, sir. You have a good day, y'all.
You too.
Good morning, Your Honor.
Good morning.
The first person coming up for you is Mr. Buford.
Okay. Mr. Buford, sir, you've been charged with a number of offenses. Driving a vehicle on expired tag, possession of marijuana less than an ounce, driving a vehicle with license not on person. I've set the bond for those offenses at $500, $1,500, and $500 respectively. There's a $2,000 bond for obstructing an officer. And at this time, I'm denying bond on the felony theft by receiving stolen property and the felony of possession of tools during the commission of a crime. I've set a preliminary hearing date for April 12th. And I've also set a bond hearing date for April 16th. Do you want me to see if you qualify for the appointment of a lawyer? You're gonna hire your own lawyer or you're gonna represent yourself?
I need a lawyer.
Okay. You do qualify, Mr. Buford, so I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Yes, what was my bond denied for the?
Well, based upon the allegation that there were 9 catalytic converters and that you had tools that are normally used for cutting catalytic converters, and they've identified at least one of the vehicles that the catalytic converter was attached to. So I'm exercising my discretion to deny bond at this point.
So I have 1 count of theft by receiving or 9 counts? How many do I have?
You have 2 felony counts. One is theft by receiving stolen property. The other is possession of tools during the commission of a crime. The other 4 are misdemeanors. So that's why bond was set on those. Bond, every person charged with a misdemeanor automatically gets a bond.
So when will I be able to get a bond for the other 2 charges?
I've set those dates, at the latest, the preliminary hearing date, I'm sorry, the bond hearing date is April 16th. But I've appointed you a lawyer. The lawyer can most likely speak with the district attorney's office and they may consent you're getting a bond on those charges that I've denied bond on, but they're probably going to put different conditions on you.
So when can I talk to my lawyer and see if he can get me on a bond?
The paperwork is going to go to the public defender's office today. And so it'll take maybe a day or 2 for you to get into their system. If you haven't heard from them, you can contact the Clayton County Public Defender's Office and let them know that they've been assigned to represent you and you need to speak to a lawyer about your case.
Okay.
Anything else?
So when is my bond hearing date or my preliminary hearing date? April 13th?
It's April 12th.
Okay. And I should be able to get a bond or whatever, or talk to a lawyer or something.
Most likely you will. Um, this is something that based upon just the number of catalytic converters and this may be something that is deeper than they knew at the time of the arrest. I don't know.
You said it might be deeper.
Yes, deeper. That there may be something more involved than just, you know, a person doing something stupid. Anything else?
Yeah, I don't quite understand what you're saying about there might be something deeper. I don't like what.
Well, non-catalytic converters, you know, that's not just hey, I needed some money, so I got a catalytic converter to go try to sell it and do something with it. If there are non-catalytic converters and tools that are in the car to easily cut through catalytic converters, this may be something that there may be 100 catalytic converters that have been stolen. I don't know, but that's why I'm exercising my discretion at this point to deny the bond.
Okay. Thank
Okay.
you, sir.
You're welcome.
All right, next we have the honor, Mr. Blackshear.
Okay. Mr. Blackshear, you've been charged with 1 count of simple assault. I'm going to set the bond at $3,000 for this, but I'm also I'm going to set the bond at $3,000, but I'm also going to set a stay away provision on the bond to stay away from LaGersha Lewis. Do you believe you can post this bond?
No, Your Honor.
Okay. Do you understand the stay away provision, to stay away from Miss Lewis?
Yes, Your Honor.
Okay. Would you like me to see if you qualify for the appointment of a lawyer?
What if I can have call somebody to make that bond for me? My family member?
Yes, you'll be allowed to contact whomever you want to contact after this hearing.
All right, I'll take the bond then as well.
Well, it's not an either or. You can get one and you can get an attorney appointed.
All right, thank you. I'll take that and an attorney appointed.
Okay, how much do you earn per month?
An average where I work at now, less than $900, maybe $700.
Okay, you qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for April 13th, but that date is going to get waived upon your bonding out. Do you have any questions of me, Mr. Blackshear?
No, sir.
Okay, you're free to go back.
Thank you.
Okay, next, Your Honor, is gonna be Butler, Ricky.
Okay. Mr. Butler, you've been charged with 1 count of giving a false name, address, or date of birth. I've set a bond at $2,000 for that. Do you believe you can post that bond?
Yes, sir.
Okay. I do believe, though, that at least in the paperwork, it said that you had active warrants out on the jurisdiction. So you may get transported to Ben Hill County after posting bond here. You're going to have a preliminary hearing date that's going to be set for April 13th. That date will get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own lawyer?
Yes, sir.
Okay. Do you have any questions of me, Mr. Butler?
After I post the bond, how long do they have to come get me a transfer me or what?
Generally, it takes less than 30 days, but that's something that I just, there's not like a set time. Okay. Anything else?
That's it.
Okay, you're free to go back, Mr. Butler.
Next is Philip Cribs.
Mr. Krebs, you've been charged with 1 count of possession of marijuana less than an ounce. The bond for this is automatically set at $1,500. Do you believe you can post that bond?
I think so.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Krebs. So I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you have any questions for me, Mr. Cribbs?
No, sir.
Okay, you're free to go back.
Next is Ms. Green.
Mr. Green, you've been charged with one count of malice murder. I am not allowed to set a bond on this offense at this time, but I've set a preliminary hearing date for April 12th, and I've set a bond hearing date for April 16th. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer? Okay. Do you have any questions of me, Mr. Green?
No.
Okay, you're free to go back.
Next, we're gonna be Grady. Gaddy, my bad. Mr. Gaddy.
Mr. Gaddy, you've been charged with one count of battery. The charge at this point is going to be dismissed. And the reason it's being dismissed is that the officer did not identify a victim. He just said the victim was your girlfriend, and for legal purposes, not sufficient. That does not mean these charges can't be brought back, because it's just a legal technicality as to why it's getting dismissed at this point. Do you have any questions of me, Mr. Gaddy?
So I'm just free to go with no bond.
Yes, once they process this, you will be released.
How long does it take to process?
When I'm done with this hearing, I do the paperwork and I send it back. We have a short calendar today, so they should get the paperwork back pretty quickly. And then they begin the process of entering the information into their system on the sheriff's side. And once that process is complete, they will let you go.
I mean, I was really just asking, do you think it's gonna take like days, or is this like an hour process, 2 hour process?
It's not gonna be an hour. It's something that should be accomplished within a couple of hours.
Okay, I don't got no more questions. Thank you.
Okay, you're free to go back.
Mr. Grant.
Mr. Grant, you're charged with 2 drug-related offenses, 1 possession of firearm during the commission of a crime, and 1 use or possession of drug-related objects. I've set the bond for the 3 felony offenses at $10,000 apiece. That's a total bond of $30,000, and then $1,500 for the use or possession of drug-related objects. So your total bond is going to be $31,500. Do you believe you can post that bond, sir?
Yes, sir. You said how much it is again? I can write it down.
Yes, $31,500. You're going to have a preliminary hearing date set for April 12th at 8:30 in the morning, but that date will get waived upon your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Well, you can see if I qualify for one.
You do qualify, Mr. Grant, from going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
So one thing you should be aware of, I think there were maybe 2 other individuals charged with the exact same thing. So there are going to be conflict-related issues as it relates to the lawyer situation. These are all felony situations, so one person will be represented by the public defender's office, and the other 2 will be represented by a lawyer that contracts with the county to handle conflict cases. Okay? All right, you're free to go back.
Next is Mr. Greenhouse.
Mr. Greenhouse, you're charged with the exact same offenses as Mr. Grant. However, it was shown in your criminal history that you're currently on probation or parole, and I'm not allowed to set bond on those felony offenses at this point. I am going to set a preliminary hearing date for April 12th, and they're gonna have a bond hearing date for April 16th. You're gonna have a bond set on the use or possession of drug-related objects, because that's a misdemeanor charge, and the bond is gonna be set at $1,500. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
My own lawyer.
Okay. Your preliminary hearing date is set for April 12th. I don't know if I said that already. I think I did. Yes, I did. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Okay, next is Mr. Hill. Clayton.
Sir, you've been charged with 3 misdemeanor offenses: driving under the influence of alcohol, driving a vehicle without a valid license, and improper lane change. I've set a total bond of $6,500. Do you believe you can post that bond?
Yes.
You're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, so I'm going to appoint a lawyer to represent you. Do you have any questions, of me, sir?
No.
Okay, you're free to go back.
Next is Mr. Johnson.
Mr. Johnson, you've been charged with 2 misdemeanor offenses: possession of marijuana less than an ounce, and use or possession of drug-related objects. The bond for both of these offenses is set at $1,500 each, and that's a total bond of $3,000. Do you believe you can post that bond?
Yes, sir.
Okay. You're gonna have a preliminary hearing date that's gonna be set for April 13th, but the date is gonna get waived upon your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
If I, qualify.
You do qualify, Mr. Johnson. I'm appointing a lawyer to represent you. Do you have any questions of me, sir?
No.
Okay, you're free to go back.
Next is Mr. McMillan.
Okay. Sir, you've been charged as same as Mr. Grant and Mr. Green. How you're setting a bond at $10,000 for the 3 felony offenses, $10,000 each, for a total bond of $30,000 on those felonies, and $1,500 for the use or possession of drug-related objects. So that's going to be a total bond of $31,500. Do you believe you can post that bond, sir?
Yes, sir.
I'm setting a preliminary hearing date for April 12th at 8:30 in the morning. That date will get waived upon your bonding out. Hiring your own lawyer representing yourself, if you want me to for the appointment of a lawyer.
See if I qualify.
You do qualify, Mr. McEwen. I'm appointing a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Next is Joe.
And that last name is spelled N-D-A-W.
Yes, sir.
You've been charged with 1 count of simple battery. I set the bond at $5,000 for this. I've also placed a stay away provision on the bond to stay away from a Yasin Ding. Do you believe you can post this bond?
Yes, sir.
Do you understand the stay away provision?
Yes, sir.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, so I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date set for April 13th, but that date is gonna get waived upon your bonding out.
Okay.
You have any questions, sir?
No, sir.
Yeah, you're free to go back.
Next is Mr. Smith.
Mr. Smith, you've been charged with one count of family violence battery. I'm setting the bond at $5,000, but I'm also putting a stay away provision on the bond that stay away from a Karika Shaw. Do you believe you can post that bond, sir?
Yes, sir.
Do you understand the stay away provision?
Yes, sir.
Do you have any questions for me about that stay away provision?
The address is to my crib. Am I allowed to go to my crib or do I have to find another place to register?
You're gonna have to find another place to reside while this stay away provision is in place. Now, if Ms. Shaw leaves that residence, then you of course can go to your residence. It's not about staying away from the residence, it's staying away from Ms. Shaw. So if she's residing there also, you're gonna have to stay away from the residence. Now, what you can do is upon bonding out, make arrangements with the sheriff's department so that you can obtain some of the items that you may need to live your life while this is pending. The sheriff's department, they're not gonna be there all day for you to move out, but they will set a time with you for that to happen. You're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Lawyer.
I'm sorry.
I'm gonna hire my own lawyer.
Okay. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Smith.
Next is Mr. Solomon.
Mr. Solomon, you're charged with 4 misdemeanor offenses. Concealing the ID of a motor vehicle, the bond is set at $500. For that, driving on a suspended license, the bond is set at $1,500 for that. And an open container violation where the bond is set at $500. You also have a driving under the influence of alcohol charge. The bond is going to be set at $5,000. So you're going to have a total bond of $7,500. You believe you can post that bond, sir?
No, not at this time.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Approximately how much do you earn per month?
Approximately about 1,200.
Okay, you qualify for a lawyer, so I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date that's gonna be set for April 13th, but that date will get waived upon your bonding out. Do you have any questions of me, Mr. Solomon?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome.
Next is Mr. Wells.
Mr. Wells, you've been charged with 1 count of criminal trespass as a misdemeanor. Mine is gonna be set at $3,500 for that. And I've also put a stay away provision on the bond to stay away from an Ashley Wesley. Do you believe you can post this bond?
Yes,
Do you understand the stay away provision?
yes.
Would you like for me to see if you qualify for the appointment of a lawyer?
I hire my own lawyer.
Okay. Do you have your, told you about your preliminary hearing date is gonna be set for April 13th, but that date is gonna get waived upon your bonding out. Do you have any questions of me?
No, that's it.
Okay, Mr. Wells, you're free to go back.
Thank you. Okay, the last one goes to future for justice, Mr. Ragland.
Okay, Mr. Ragland, your situation is gonna be a little bit different than the others. You're charged with being a fugitive from justice. The same rights that I read to everyone else in the beginning still apply to you. But you're gonna be in a situation where there are apparently 3 jurisdictions that want you to deal with certain charges. There's the Dothan, Alabama Police Department in Dothan, Alabama. And they say that they have a warrant for your arrest for unlawful breaking and entering in a motor vehicle. There's Volusia County Sheriff's Department in Daytona, Florida. They say they have warrant for your arrest for illegal use of credit cards. And then there's Auburn Police Department in Auburn, Alabama, that says that there's a warrant for your arrest for larceny from an auto is the charge. And they all say that they want to extradite. And so the extradition process is one where you can fight it if you believe that you don't have charges pending in the jurisdiction or that the warrants are not valid. You can say, look, I want to fight that here in Clayton County. And you will be entitled to, they call it a habeas hearing, but you'll be entitled to a hearing where a judge sitting in magistrate court will have to make a determination as to whether there are valid charges that are out pending. But it's not a situation of determining whether you're guilty or innocent. So the hearing only will be to determine whether you are Sheriff Andrew Ragland and whether the charges that are pending for these warrants are valid charges. And once we find that out, then a warrant, extradition warrant is signed, and you can go about your business dealing with these charges in the varying jurisdictions. The benefit of a waiver of that hearing is that it starts the clock running for everything. And generally speaking, if jurisdiction doesn't come and get you, they have up to 90 days, it's written 60 days, but if they don't come and get you, you can get released. If they do come and get you, of course, they take you and deal with varying charges. Because you have charges pending in 3 different jurisdictions, I believe whomever comes and gets you first will be the first place that you go. And then the other place will have to deal with you. So if Auburn, Alabama comes and get you first, and Dothan, Alabama, and Dayton, they'll have to file charges or extradition warrants in those jurisdictions. Have you thought about whether you want to waive your preliminary hearing or waive your extradition hearing or have your extradition hearing?
I want to wait.
Okay, so the deputies there are going to give you the forms to sign, and then they're going to send the forms to me today, and I'll sign them and send them back. Do you have any questions of me, Mr. Ragland, about anything that we discussed here?
No, sir.
Okay, you're free to go back. Once you sign it, they'll have the forms there and let you sign the forms, and then you'll be free to go back.
All right, thanks, sir.
Yeah.
Okay, y'all, okay, y'all, that's it for the mail today, sir.
Okay, enjoy your day.
Yes, sir, you too.